You see my screen?
It says its share has started. There it goes. There it goes. I see it.
Okay. I've got some real funky stuff going on here on this computer. Admit everybody. Get everybody in. Okay, I think we are good to go now. Can everybody see everything okay? Can you see it okay, Jesse? All right. Okay. Good afternoon, everyone, and welcome back to the A Month of Service collaboration presentations. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. And so we want to welcome you all to today's presentation of Wills in Advanced Legal Planning and Why Do You Need It? And today we are being presented with information from our presenting partner with Lone Star Legal Aid. We have Ms. Jessie Campbell. Also included in the partnership, we have the City of Houston's Department of Neighborhoods, the Earl Carl Institute, Harris Central Appraisal District, the Houston Volunteer Lawyers, Texas Legal Services Center, as well as the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And basically what A Month of Service is, it is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the community that do not have access to a lot of information and resources to know where to go for particular types of services and things that can help with their protecting their assets, with building assets, protecting their generational wealth and community empowerment. So, we have Miss Cecile Carlson just joined us with the City of Houston Department of Neighborhoods. But we started these workshops several years ago in an effort to, we came together in an effort to try to reach more people, create a larger platform, and get as much information out to the community as we possibly can. We thought that it only made sense considering we do serve the same communities, and some of us have similar missions and goals in mind. So we wanted to, so we created that collaboration between all of us to do just that. Unfortunately, we've only been able to do the virtual platform for the past several years, but we've been trying to slowly get back out into the in-person session. However, we have been able to expand the reach of our people that we've been getting information out to, and expanding the topics that we've actually offered on a monthly basis, um, to to include a variety of other different workshops that we also have. So we want to thank you guys, for your input and your feedback and your constant support and participation with the Month of Service collaboration. So without your input, then we would not be able to expand these programs and different initiatives that we are currently offering. So do know that that your voices are heard from us. If there are any other workshops that we don't currently offer that you all may be interested in, then we ask you to reach out to us and let us know. Um, do know that also that any of the legal presentations that we do offer is for informational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you find yourselves in need of any civil legal assistance. Also, do know that this is your opportunity to be interactive. Feel free to type whatever questions that you may have into the chat. I know I have received a couple of questions that were emailed to me in advance, and I'll make sure that we get those read aloud and get those addressed, but there's a lot of information that's going to be covered here today. So do know that we're going to try to get to everybody's questions as quickly as we possibly can. You will have the opportunity at the end also to either unmute yourself. If you are joining us on any of our social media platforms, please type your question into the comments section, and I will try to get those addressed as well. Do note that we do record our sessions as well as, again, broadcast live on our social media platform. So do keep in mind that we want to try to protect your privacy as much as we possibly can. So we do ask that you try to keep your questions to be as general in nature so that your personal information is not getting out there for everybody to actually have access to. So do keep that in mind as you're asking your questions. So with that being said, again, there's a lot of information that's going to be covered here today. So you guys are more than welcome to continue to come back each month. We do this particular presentation the first Thursday of each month, and in similar variations, but the overall gist is pretty much the same kind of topic. But and then Miss Jessie is going to go into a little bit more detail about that. But you definitely can join us here the first Thursday of each month at 1 p.m. for this presentation. We do encourage you to share the information, pay it forward, and help get this information to out your neighbors, your family members, your coworkers, or whoever that may also feel that this information is beneficial to them as well. So um, without further ado, let's get right into it. And again, we want to thank you guys for joining us. And Happy New Year 2025. This is our second one. We had our first one yesterday. So, but we're back in the swing of things. And thank you guys for coming back and for the new folks for joining us for today. So, Cecile, why don't you have you introduce yourself, and then Miss Jessie will have you introduce, and then we'll get right on into the presentation.
Hi, good afternoon, everybody. Thank you all so much for joining us. Nia, thank you so much for that great introduction. And thank you, Jesse, for being here. Very excited to learn a little bit more about wills. This is very important information. Like Nia said, please, 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 if you know anybody that might be interested, share this link. Share the information that we have. This is coming straight from the experts, so we know it's information that is useful, that's vetted, that comes from experience. So I'm very excited to hear what Jesse has said. Sure. Thank you all so much for being here.
Okay, Jesse.
All right. Well, thank you, everyone. I appreciate your time today. Once again, my name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and today's presentation is on legal advance planning and why you need it. And I'm going to talk more about what we're going to discuss in a minute, but that is going to be today's topic. A little bit more about Lone Star Legal Aid. We are a legal aid service organization. Our service area includes 72 counties in the eastern and Gulf Coast regions of Texas and 4 counties in southwest Arkansas. We have, in addition to our Houston headquarters, we have 13 other branch offices throughout our service area. All of those are listed on the screen there. We provide free legal services to eligible households, and it's based on income and assets. We do always recommend that don't assume anything that in terms of eligibility. If there is a possibility that you are eligible for services, we recommend that you apply and see if you qualify. The types of law that we assist with are civil legal services, and so we don't assist with any criminal cases or like traffic tickets or personal injury. Those are the types of things that we don't handle, but kind of the everyday kind of law matters that people have: consumer, employment, family, health, housing, landlord-tenant, juvenile issues, neighborhood problems, public education, public benefits, estate planning, and probate, just to name some of the things. That isn't even everything that we do. That's our contact information, and it's also on the screen right there. So you can always write that down. All right. So, as Ms. Nia already said, this is for educational purposes only. So don't take this as legal advice in general. That also goes the same with questions. I cannot answer and provide legal advice on this call, on this presentation. So please don't ask me questions that require me to do that. What does that mean? I can't answer in very specific fact questions, right? Like you can't sit here and tell me, hey, I really want to write a will that gives everything to my granddaughter in this way. Like, what do I need to write? Like, I can't do that today. So be mindful of that. Anything that requires specific knowledge about your case, I cannot answer. Also, this is a public forum, it's public space. In addition to the Zoom call, if you're on the Zoom, if you're watching us via live on one of our social media sites, all that's available. People will be able to see your comments and your questions there, and we do not want you sharing any private information anywhere that will live on the internet forever and that can potentially be used by a bad actor in some way. But that being said, please do ask your questions. If you are on the Zoom, feel free to put it into the chat. I do look at the chat as I go, and I tend to answer them as I go. But if you prefer to ask the question orally, like unmuting yourself, I ask that you wait till the end to be able to do that. For those watching live on our social media sites, you can put the questions into the comments on those sites. Someone will be monitoring that and will ask the questions at the time that it's appropriate, either via chat or at the end. So feel free to do that. But again, remember, no private personal information. Internet's forever. Everyone can see it. All right. Okay. So today's agenda. So I typically do the same presentation every month. We have started shifting that at the end of 2024 and be going into 2025. We are shifting that. It's a lot of information and it's a lot to cover in 2 hours. And so I've kind of split the topics into two different sessions. So today we are going to be talking about what is advanced planning at kind of a high level. What do I mean by a high level? I'm going to tell you what it is that we're talking about, what you need to be thinking about, and then the types of advanced planning that we do and the types of documents that you need to have or may need to have if you are preparing for those types of situations. So that's going to be what we're going to be talking about today. I am not going to be going into specific details about the documents and what you need to do to write them or what the requirements are to execute those documents, except to a very brief degree. Next month in March, via Zoom, I will be doing what is my secondary part of it, which is how to draft a will and a transfer on death deed using Supreme Court forms and state approved forms. So that way, for those of you who are not going to be who are not going to hire an attorney or be able to apply for services to have one of the legal aid providers draft the documents for you, then you can look to see how you can draft those documents yourself. So that's going to be the second half. And that is where I'm going to talk more about the requirements of a will, what needs to be included, what you need to have in it, and to be able to have a properly executed will at that point in time. So just kind of be aware of that it's kind of a two-parter in that way. So if you have questions today about how to draft a will, what the requirements are, I'm not going to be covering that today, but I do recommend if you cannot wait until March, those recordings from the last presentations at the end of 2024 are available on our YouTube channel. Please go and check that out. So that's the housekeeping part of it. So again, that's the agenda for today. We're going to talk about what is advanced planning. Then we're going to talk about the types of advanced planning, which are 4 basic categories: planning in the event of our death, planning for the caring of ourselves when we are unable to do so, caring for those in our care when we are no longer able to do so, and then of course there's long-term care. Then at the very end, we'll talk about some available resources. So what is advanced planning? Advanced planning is exactly what it sounds like. It's preparing and planning. You're thinking ahead for what you want to happen when certain situations arise or may arise. And what are those situations? We're talking about death. It is a reality. And for most people, that's what they think of. When you hear the word advanced planning and you're usually thinking about estate planning. You're thinking about planning for our own passing and what we want to happen with our property, who's going to inherit the property, taking care of people that are in our care in the event of our passing, managing our debt, making sure debt gets paid for if anyone owes us money, collecting our money, transferring title, making sure that the home that's owned gets properly transferred to the heirs and so that they have free and clear title to it. So that is kind of that is what most people will think of when you say the word advanced planning, is planning for one's passing. And it typically is around property, but it also can include those who are in our care. We also, when you're thinking about advanced planning and the full slate of documents when we're doing advanced planning, includes who we want to take care of us and handle our affairs in the event of our incapacity. So what is incapacity? We are no longer able to make decisions for ourselves. That's what an incapacity is. You're thinking about potentially being in a coma or dementia or unconscious for whatever reasons, right? So those are what we are thinking of when we're thinking about planning for our incapacity. We're still here, but someone needs to manage our property and they need to manage us, our health, our well-being, and the care for us. And so that would be planning for incapacity. Again, for most people, when you hear the word advanced planning, estate planning, that's what you think about. You're thinking about your death and you're thinking about caring for yourself, those kinds of power of attorneys and documents. We're going to talk about all that. But advanced planning also includes other types of things. Advanced planning will include caring for those in our care. So sometimes you may not hear that referred to as estate planning or advanced planning. You might hear it has referred to as family readiness, preparing for the caring of those individuals who we are responsible for. So those are our minor children's as well as adults for whom we bear responsibility for, either through a guardianship, which is the court ordered legal requirement to care for somebody and manage their affairs, as well as the informal care. These are individuals who are adults, doesn't really require a guardianship, or a guardianship has never been established, but we are maintaining the care for them and handling things in our affairs for them. So it's also thinking about how do you help prepare for those individuals to be sure that they have things in place, the documents are in place, so that way subsequent successor caregivers and individuals responsible can come in and do what they need to do to be able to care for those individuals. So that is also part of advanced planning. And then the last category is honestly pretty new. It's been a couple of decades, but it's something that as we are living longer and we are uh, which is good, right? Yay, healthcare. So we are living longer. One of the things that long-term care planning is actually thinking about how do we preserve our assets while being able to gain access to necessary long-term medical care. So thinking about like what happens if you need to go into a residential facility, a nursing home. How do you qualify for the assistance needed to obtain that care while also preserving your assets for your family and then your heirs kind of going forward, so that way you don't bankrupt yourself maintaining your medical care. So that is also long-term care. That is also advanced planning, because that is something you typically have to think about before it happens. So these are things that we are thinking about before they happen. And then putting it all into a legally binding document for the most part. I'll tell you when they're not legally binding, but when they are legally binding document. So again, what we are talking about is the before. Today we're talking about before. The need hasn't arisen yet. We're still here. We haven't passed away. We have our ability to care for ourselves. We're not incapacitated. We are still caring for our minor children. We are the parents of our minor children. So we're able to do that. And we're young and healthy, able-bodied, and not worried about our long-term care at this point. We are planning right now before it happens. What happens after the need arises, after a person passes away, after an incapacity happens, after a parent is no longer available, what happens afterwards will be contingent on what advanced planning documents are in place. And so a lot of the times, and we won't be going into full detail about the after process today. Just be aware of that. We're not going to be talking about the after process. But a lot of what needs to happen in the after process, you need to know about it. You need to be thinking about it so that way you can prepare for it. And so what are some of the things that can happen after probate? That's the proceeding when a person passes away, where we go to court. And so when we have to administer the estate to pass the property, pay the debts, and things along that lines. One of the things I really want everyone to always remember and think about, even though we're not going to talk about it in great detail today, but the thing to always remember is when a person passes away, the heirs, the executor, the beneficiary, somebody needs to do something, which is go talk to a lawyer. That's the something. When it's like, you can't just ignore it. Like, right? There's a lot of problems that can come up with that. I'm going to talk about some, at the end, we're talking about some upcoming events But if after a person passes away, you have things that you need to do, which is go talk to a lawyer so that you know what the right process is to ensure that the estate is managed and handled the way it needs to be handled. But having a properly executed will and the instructions in the will informs the court what to do if there is a probate process, or depending on what the will has and the types of documents that are in place, maybe we can avoid the probate process, or we may not need a probate process. So again, having the advanced planning documents in place will impact what happens afterwards. Same thing for our incapacity. When we are no longer able to make decisions for ourselves, the court is eventually going to get involved in sense of us appointing a person to be our caregivers and be responsible for that. That's the guardianship proceedings. Whether or not you have documents can also impact what happens in the guardianship proceedings. This is for ourselves as well as those in our care. And then for minor children, there's a possibility that there could be a suit affecting a parent-child relationship. Again, it kind of just depends on what's going on, right? One of the things to always kind of keep in mind as we kind of go forward on this is that everything is an individual plan. When we talk about planning for our own passings, when we talk about our incapacity planning, we need to take into account our own individual situations, our family members, our family dynamics, what the situation is as it relates to each of the individual family members in terms of their health, their capacity, their property. We have to kind of take into account those types of things. We need to consider the type of property that's owned, who is in our care, and what are they inheriting? Like, if they inherit property, does it impact anything that they might have, any benefits that they might have? So we need to be thinking about the individual on the other end that's being impacted by the decision making that we are making for on their behalf, right? We're doing things that will impact them. How is that going to impact them? Our health conditions, the individuals we care for, their health conditions. So these are all factors that we have to kind of take into account, which is what makes this actually a pretty complicated thing. It's one of those things that you hear a lot about, and I'm going to do a whole presentation next month about being able to draft your own documents, but it can get pretty complicated. And one of the things that you always have to kind of, what's really difficult as a lawyer, and I always kind of do this push-pull on kind of advising or talking about it, which is that as a lawyer, we're trained to see around corners. I always kind of joke, I call myself Bad News Jessie, because I'm always thinking about the bad news that can happen. But that's my job, right? I'm here to look around corners that you may not know a corner exists, and to be able to say, hey, we need to be thinking about this, about when we're drafting your documents, we need to be thinking about that. And so I always recommend that if you have the ability to do so, that you should try to hire an attorney if you can afford one, or if you can't afford one, apply for legal services for someone to be able to help you walk through that process, because there is so many nuanced factors around this individual plan that sometimes a standard form will not apply. But on the other hand, the other part of me, the lawyer part of me, also knows, and Bad News Jesse, is that if you don't have a will, that can create a lot of problems. If you don't have a medical power of attorney, that can create a lot of problems. And so in some ways, there's a part of me that's like, well, I would rather you draft your own documents. They may not be perfect documents and they may not capture everything. But if you are in that in between, you don't qualify for services, but you still can't afford an attorney, that at least you can have something in place. So that way you do have some protection. It may not be perfect protection. Not saying it's perfect when a lawyer does it either, but it's but it's but having something in place is better than having nothing in place. And so I kind of go back and forth on that. But the key thing about this slide that I want you to walk away from is just remembering that you need to be aware that you need to be thinking about things that make you unique. And you can't just talk to your neighbor and find out what your neighbor did. You may look the same as your neighbor. You have the same house, or maybe a different floor plan, but you're obviously neighbors. You may have the same family dynamics and family structure, and they have gotten their documents. You can't just look at their documents and be like, oh, can I just copy it? Because they have individual needs and differences that are different from yours. And so that would be the key takeaway, is to always keep in mind, how is your family uniquely different from other families? And it doesn't mean that the standard forms won't work for you, because they may. They may definitely work for you. But you need to be aware that there may be a nuance, a difference where they may not work for you. So when to update your documents? Generally, you always they're living documents, right? They once it's never a one and done. I don't think some of them maybe, but not always. So you do want to check them regularly, and some people check them every year. They're like, "Yep, looks good to me," and they don't need to make any changes or things like that. But there's a lot of people who once they do it, they don't really think about it afterwards. They put it into their safe location, and then they're like, "Well, I'm safe. All my stuff is put into place." But you should still check them every once in a while. Be sure that they still do what you need them to do. And those really, it's around major life changes is when I tell you really that's when you need to look at it. So life changes is changes in marital status, marriage, divorce, widowhood, separation. By the way, I mean usually we think of the legal status. But a separation, you've separated, but you're unable to get divorced for whatever reason, or the separation is forced in some way, but a separation may require some planning that needs to be put into effect. And so some changes in marital status and living situations, maybe I should say that as it relates to partners and family dynamics. Children, as you have new children and more children are born, that you need to be considering that. Unfortunately, some people do have children who pass, and thinking about what happens when a child passes, but it also includes when children are aging. And so things to kind of keep in mind. Does the child, has they aged, do we identify disabilities that we need to be taking into account? And then has they turned into adulthood? When they turn 18 years of age, the needs for the planning that existed when they were 7 is going to be very different from when they are 17 versus when they are 27, right? So we would want to be looking at our estate planning documents at that point in time. Health changes, our own health changes, our children, our beneficiaries, we want to be kind of taking account what's going on there because that may impact what kind of documents, what kind of changes you may want to put into your documents based on prognosis and conditions, etc. And then major property changes. And I don't mean I mean big property changes. I mean like you bought a house, you bought a car, you sold your house. But it could also include like establishing retirement accounts. It could be a big inheritance. So right, but major property changes. We don't have to worry about clothing or things along that lines. Those kinds of things change pretty frequently, even high value things. But think in terms of property for which there is either a high value associated with it, but typically that there's some type of a legal document that shows you own it. That's really kind of, if you have a legal document that shows you own it, a title, a deed, and that is a type of property you need to be looking at whether or not your estate planning currently reflects being able to manage that in the event of death or incapacity. In many instances, all these documents are going to be choosing somebody to serve as your representative, someone who's going to be stepping into your shoes and acting on your behalf when you are unable to do so, either to death, incapacity, or unavailability. And so when you're thinking about that, you really need to be thinking about someone that you trust and will do what's in the best interest for you, your family, the people in your charge, or as you would do it. It's not the same, by the way, right? Like it's not the same thing as what they think is in the best interest for you. It's what you think is in the best interest for you and the people that you care for. And so that can be a little bit hard, right? Like sometimes, it's not that they're bad people or that it's not a loving decision, but it's not the decision you would make. So you want to pick the people who can do that, who have the emotional ability, the spiritual ability, to be able to make the decisions that need to be made. That can be difficult. And, so you want to be sure that someone has the ability to do that. There's going to be times where you can pick more than one person. Generally, depending on the document, I highly recommend against having multiple people. For example, I do not recommend co-executors. I do not recommend co-power of attorneys in your statutory durable power of attorneys. I think there are things that really you should avoid, having dual or multiple people having with the same powers. But there's some things where you may need one. And so generally, I always recommend if you think you need more than one person to serve as the representative, I highly recommend you talk to an attorney about it so that way you are truly aware of the potential consequences of having more than one person who has the same ability to make the same decision and counter each other, because that's really what you're trying to avoid. It's going to be a very sad situation when you have done all of this work to do your advanced planning and put things into place, but then you put two people who are going to serve in that role, and then they fight each other, and then they can't decide on what they're going to do, and then all of a sudden it's still going to end up in court, and some judge who you do not know is now going to be making decisions on behalf of your property, you or your family. And so, and nothing against the judges. They're wonderful people. It's not, but they're not you, right? Like it's someone else coming in who's going to do their best. They're going to look at the facts. They're going to hear what people have to say, and they're going to make an objective decision on what the law allows them to do. And so, or dictates them to do. And so, but we generally want to be and make our own decisions when we can, right? So we're trying to avoid conflict. And so choosing multiple agents, multiple representatives with great care, highly recommend if you're able to do so, talk to an attorney about it before you do so. Then you're going to want to discuss the decision with the people. Don't let it be a shock. Don't let it be a surprise. By the way, you're my executor. And they're like, wait, what? I didn't know it was going to be the executor. Talk to them about it. Be sure that they're informed. Give them the information that they need. So that way, if they are put into a position that they do have to make a medical decision on your behalf and you're not able to give them more guidance, that they already have the information that they need, that they understand how you would make these decisions and things on that line. Give them an opportunity to be able to say no. Sometimes you need some assistance having a conversation with that. It's not uncommon that when we're drafting documents for clients, that maybe the attorney needs to bring in the agent and the executor and explain what needs to be done and what needs to happen, and kind of mediate that in some way. I mean, it's not unheard of to use counselors and things like that. And not saying you always need to, but sometimes you need that as assistance, and it's okay if you do. And then have alternates. You don't want to just have one person and that's it, right? Have an alternate, so that way if the one person that you've chosen is unable to do so, then you have another person who can step into the role if they need to. And of course, just like you're going to have all of the same thought process of like who you trust, having same conversations, you're going to do the same thing with your alternate. And so that way they are also empowered and prepared to take on the role when the time comes. All right, so let's talk about death. It is going to be the biggest part of our presentation, but this is actually a slightly new PowerPoint, so I'm not sure, but we're going to talk about death right now and the documents you need for that and preparing for that. So first, I want to kind of explain some misconceptions about what happens when a person passes away and the transfer of ownership of property upon death. And these misconceptions can kind of lead to people thinking they don't need a will or they don't need to do something. And I'm going to dispel that. The hope and the goal by the end of this slide, well, actually the next 4 slides, is that you're going to realize that the takeaway from that is everyone needs a will. Everyone needs to prepare for this. So, right. So one of the things that's kind of a misconception is like, oh, I don't really need a will because I don't own anything. Really, what people tell me, what I'm hearing when people say that to me is that they think they don't own anything of value, and of substantive financial value. Here's the thing. There's a lot of emotional and spiritual value to property. There's a lot, people put emotion into things. And so there's that. You could have a lot of sentimental value in things. Plus, everyone owns some personal property. And even if none of that exists, you own property. You have your clothing, your furniture, your jewelry, all of that exists. And someone has to be able to do something with it. If you're living and you're renting or living in a facility, someone has to be, who's going to come in and take the property and do what they're going to do with it? Are going to have an estate sale? Are they going to donate the money to a nonprofit? Is it going to go, who's going to get the money? Right? So there's actually things that you do need to do when it comes to personal property and give instructions on what to do with that. So it's actually untrue. Everyone owns something for which you need to give instruction to what you want to happen to that something. And so, and that really leads me to the next point. Someone must have the authority to do something with it. Who's going to be in charge? Who's the one that's going to make those decisions, and what instructions is going to happen to that? And it kind of goes into title property at this point. And so title property, we're talking about cars and land and houses is really what we're talking about here, is that they must go through a legal process to clear that title. It's not automatic. And so like who owns the property? When we need to go find out who owns a house, we go and look at the county records and look for a deed that says who owns the property. And so when a person passes away, someone needs to do something to change the title of that property from the person who passed to whoever the heir is, whoever the beneficiary is, and the new owner of the property. And so that needs to go through some type of process. And there is some safety nets according to state law and things like that. But you may not want the safety nets in place because it makes an assumption. It's kind of like, well, we think you want your property to go to your whoever, like your spouse or your children, but that might not be the case. You might, again, remember, individual plan. You might need someone who needs a life estate. The person inheriting it may be receiving benefits that are income based, and you need to be planning for that. So there's things that kind of come into play, and so you may not necessarily want that safety net that the government has put into place, and to be able to do that. So, but there is a misconception around that because I hear things like, "Oh, the kids are going to get the house anyways; it doesn't matter." Maybe because that's what the safety net puts into place. Depending on your family situation, that might be what will happen. But you still have to do something. Like just because that safety net is in effect doesn't mean that someone down the line is going to be like, "Well, who owns the house?" You haven't done anything. You have to do this process, and you have to do something about that. And usually, a will or another document transfer on death deed is what kind of helps you facilitate that to be sure that it does happen. Um, Cloudy titles can impact the value of your property, being able to sell it down the line. It gets much more expensive to clear title to property with multiple generations for a home, inherit a home that has not gone through the clear title clearing process of whatever format that may be. It can impact your access to resources, property taxes, exemptions, and if there's a disaster and you may qualify for assistance to home repair, having a cloudy title can impact that. So the takeaway I really want you to take from that is that you must do something with your title property in order to make sure your title is clear. The other thing that people will tell me is like, oh, we're all set. We agreed. We already agreed this is what's happening. Verbal agreements as it relates to land and houses are not enforceable in the state of Texas. And so it's like when I hear that, I'm like, fantastic, put it into writing so that someone can actually enforce that agreement. Because when one person of a two-party verbal agreement is no longer available, how do you enforce it? How do you enforce that? There's nothing to indicate that that was what was agreed upon. And the survivor of that agreement can do whatever they want because there's nothing else to say otherwise. Again, bad news, Jesse. I'm here to say people sometimes don't do what they say they're going to do. So we want to be sure that we kind of protect against that. Um, and the other misconception is that a co-owner does not automatically inherit the property when the other co-owner passes away. There's a kind of, and I think that comes from the community property ideas. Like when you're married and you buy a house, your surviving spouse is going to get the property. Ish, like it depends. It depends on whether or not there's children from a previous relationship. So and there's other factors that can kind of come into play on that. So it's not always true that the surviving spouse or the surviving co-owner of the property inherits the property. So you want to be sure that you put the documents into place if that's what you want. All right, so the biggie, the big document that everyone knows about is the last will and testament. It's a legal document in which a person called the testator writes down what they want to happen to their property and debt that's collectively known as the estate after their death and who they want to manage that estate. That person is known as the executor. That's really all a will is. And it's can be pretty straightforward. It can be, everything to my spouse. At least I name, my neighbor to serve as my executor. And that's it. Like that could be enough, right? Like, oh, that's not a good will. Don't write that. But but that's really all it is. The key thing I want you to walk away from this, and ultimately at the end of all of this, everyone needs a will. I don't care what anyone says to you about like, oh, I'm gonna do you can avoid the probate process if you draft this document or blah, blah. No. Everybody needs a will. I can regale you with so many stories about what happens when someone doesn't have a will, and as it relates to life insurance policies that come out of the woodwork. You think that doesn't happen? It happens. People have life insurance policies that they don't know about. And now who gets the life insurance policy because there's no beneficiary listed on it? We get inheritances that we're like, well, now what happens to the inheritance when the person has passed, and needs to go according to the estate if the inheritance is set up in such a way that it's supposed to pass to that person's descendants, right? So things happen, and it's better to have a will and not need it than to need a will and not have it. Having a will also impacts the probate process. Remember, at the beginning I said there's the court process. If you have no will and you have titled property, chances are you may be forced into a probate process. And that probate process, the time, the expense, the ease, how easy it is to go through that process depends very much on whether or not you have a will. And so having a will will make it less expensive because you're not going to have to, the attorney is not going to have to do as much work in court and drafting of documents in a way that we would if there isn't a will. It makes it faster because it will identify the heirs. And sometimes the court's going to be like, well, we need to go figure out who the heirs are. So they're going to have to hire another attorney to go represent people who may or may not exist because they got to go find those people. So that can be expensive and, of course, more time consuming. And so I really want you to walk away with, I need a will. Must have a will. And I rather you have not a perfect will, a good enough will than no will at all. And in general. But that is kind of what, oh, that's it. That's all it is. That's all I have to tell you about a will. But the most important thing about that is that it only covers probate assets. And so, because again, it's the part that the court handles. What is the court going to be handling? And the will is going to cover those probate assets. So that means we have to think about in our advanced planning our non-probate assets. And so non-probate assets are property that are owned in a way that ownership transfers to a specific person without going through the probate process. That's what it is. Our folks in Austin, because we're Texas, so our folks are in Austin, have made some laws about what, they're like, hey, these are things that if you own this property in this way, then you're going to name the person with that institution in that document or whatever, and then that property is going to go there. We don't have to worry about the probate process. And so what are these? It's going to be retirement accounts, your IRAs, your 401ks, your Fidelities and Schwab accounts and what things along those lines. So you're going to go to your financial institution, you're going to designate a beneficiary. So when you open your account, there's a form that you complete. You're going to be like, these are my beneficiaries, these are the percentages I want them to get, and you're going to name your alternates. Life insurance proceeds, they also pass outside of the probate process. When you purchase your life insurance policy, you're going to name your beneficiary, set your percentages and your alternates, and then that will happen. And then we have what is known as payable on death accounts. These are typically going to be at your financial institutions, such as your checking accounts, your savings accounts. So what those are is that it's a checking account, but you have named a beneficiary. So you've gone and you said, upon my passing, I want the checking account to go to the named beneficiaries and then alternates in that way. So all three of those, when you're talking about naming a beneficiary, what you will do is that when a person passes away, the beneficiary is going to go to the financial institution, because you're all financial institutions, and they're going to say, hey, the primary holder of the account has passed. What do I need to do? Then that institution is going to provide the instructions on what to submit. It's typically a form that they have. It's their own form. It's not like a state form. It's their own form. Plus, they would ask for a certified copy of the death certificate. Once they receive that, then they will disperse the funds according to whatever the rules are that they're allowed to do so. Retirement accounts, usually it's a rolling over to a different type of a retirement account, or if you want to cash it out. Life insurance policy is usually a check, right? So it just kind of depends on whatever the process is going to be for that financial institution to transfer the property over to the beneficiary that's been named. Now, for those three things, when does a will become important? Because I just said everyone needs a will. And you're like, well, all I own is these retirement accounts and a house. And we're going to talk about how to handle a house in a minute. So why do I need all of it? Again, people own life insurance policies that they don't know. And so when you go in and all of a sudden there's no beneficiary on a life insurance policy, and that does happen, now we need to know where it goes. It's going to go according to the will. The life insurance company is going to write that check to the estate, not to whoever the beneficiary says it's supposed to be. submitted to, this check is going to be written to the estate. And now we have to go to court and figure out who is entitled to that money, who's the heir. And that is where the probate process is going to come into effect. That's where a will will become very effective. And so having a will, they'll be able to say, hey, the anything I have in my estate is going to go to my spouse. And then they're going to be like, okay, well, now we know. We have a will that says that, probate's going to say it, and the check's going to then be dispersed to the beneficiary according to the will. Now, you're like, well, then why do I need to name a beneficiary? Expense. Look, we worked really hard for our money. I'm going to try to save you as much of your money as possible and get it to the people that you wanted to get to. I like a good lawyer. I'm one. I like my lawyer friends, but you don't need to keep paying us for things that you don't need to pay us for. So it's so for example, if a life insurance policy is $20,000 and you have a beneficiary, the life insurance policy company is going to write a check for $20,000 to the beneficiary. But if there isn't a beneficiary and we now have to go through the will process, well, you have to hire a lawyer. You have to hire a lawyer to open up a probate, and let's pretend that that lawyer is charging $2,000, right? And it's like, so it's going to be $2,000 for him to go do this process. I don't know. I actually have no idea how much attorneys charge for this. Well, now that $20,000 check is going to be, and then there's filing fees and things like that with the court. And so so let's add another $1,000 onto that for like whatever fees we net. And it's actually not that much, but let's pretend, right? Like make it easy for me to do math on the fly. And so it's like now you're gonna have like this $1,000 and and so now that $20,000 check is now $17,000. Well, that's not fun. That's why. When just having named a beneficiary on the life insurance policy would have avoided that expense. Now, this is where I kind of pinpoint the importance of having a will. So then it's like, well, what happens if you don't have a will? And you're like, well, you know what? You just told me, Jesse, that the safety net says that all of my property is going to go to my spouse if I'm married, right? And so, in many cases, if you're married and if you're married and all of your children are your spouse's children and your spouse inherits all your property, that's the safety net. So let's assume traditional nuclear family in that way. And so it's like, well, if you don't have a will, and so now you're going to go to court and be like, well, judge, we don't have a will, but person whose passed was married and all the children are the children of the spouse gets everything. And the judge is going to be like, wait. Are you sure? Are you sure there's no other children? Because people have other children. People have secret families. We need to be sure, right? So that $2,000 you already hired to hire your attorney, your $1,000 of additional costs and things like that. Now that attorney is like, oh nope, now it's changed. It's no longer a simple probate. Now we're going to have a potential more difficult probate. Now, I have to file more paperwork because there's no will. I have to do a lot more. So that $2,000 attorney is now $4,000 or $5,000, right? And now and then the court's like, well, we don't know. There's no one else. So we're going to hire another attorney to represent the person that's not in the room, right? Make sure there's no other children. There's in a secret family. And that attorney is going to charge $2,500 or $2,000, And so now what is a $20,000 policy, if I did all my math right there, is now going to be, once it's all said and done, a $12,000 inheritance. So that's kind of my walkthrough on why it's important to kind of look at all of these things, looking at making sure your beneficiaries are listed in your non-probate assets, making sure you have a will just in case something does pop up that you're not aware of, and it does save some expense. And then what would happen if you don't have a will? Okay. So the last type of non-probate asset is the joint tenancy with a right of survivorship. So remember when I talked about the misconception that when you own property together, that the co-owner the survivor automatically gets the remainder? That's not the norm. That is not the standard in the state of Texas for most property, but you can create that. You can create a joint tenancy with a right of survivorship where you say, we have chosen that this property is going to be owned together in such a way that the survivor of us will automatically inherit the property without having to go through the probate process. You can do that for not only spouses, but individuals who own property together. It's apparently quite common now for friends to purchase property together, and so like maybe they decide they want to do a joint tenancy with a right of survivorship. So it could be things like that. It also can be not only for just your house, but also for your financial accounts. And so that's something that we can do. I always like to say be a little buyer beware, because you can't change this very easily. Once you create this, everyone has to agree to uncreate it. And so which makes it a lot more difficult if you should change your mind, if something should happen, and to be able to fix this if it's not something that works. Again, it's one of those things that if it's something you're going to do, I recommend you talk to an attorney so that way you're fully aware of all the potential consequences if things should go south on any kind of relationship there. Okay, everything else is a probate asset. If it's not one of these, probate. It's going to be governed by the will, going to go through the probate process. All right. Transfer on death document. So a transfer on death document is a way to bypass the probate process. It's not a non-probate asset. Your house and your car are still probate assets. If you don't have these documents, they would be governed by the will. If there's no will, governed by the safety net laws, the intestacy laws that exist. And so, but this is a way to bypass the probate process. For many, many people, not all people, but for many people, their major assets are their house, their car, and their financial accounts. That's really what it is. Most people don't tend to have really complicated estates, so some do. And if you have a really complicated estate, I'm assuming you have the ability to hire an attorney to talk about what you need to be thinking about. For a lot of us, though, it's our home, our primary vehicles are 2 vehicles, and then our checking accounts and maybe 1 or 2 retirement accounts that we may have. And so our retirement accounts, our savings accounts, our bank accounts, things like that, we're going to take care of through the non-probate things, right? We're going to make sure that we have a beneficiary listed. We're going to make sure our bank accounts are payable on death accounts. And that's how we're going to handle our financial accounts. And that's kind of how we're going to make sure that they bypass the probate process there. Well, when it comes to our land and our cars, we can do a transfer on death document. And so you still own the property. You can do what you want with them, with your property. And you can sell your car, you can sell your house and things along that lines. But what happens is after the person passes away, the transfer on death documents will automatically be in effect. That person whose name automatically owns the property. And so that is, which means you bypass the probate process. For real property, that is known as a transfer on death deed. It is a deed, just like when you bought a house and you probably completed a warranty deed, or if you may have gotten a gift deed if it was an inherited house, but it's a deed, right? A deed is how you know who owns the property. For transfer on death, it's a transfer on death deed. It must be notarized and it must be filed in the county where the property is located. So if you live in Harris County and your property is in Harris County, it needs to be filed in Harris County and it must be filed. It's not valid if you just execute it and stick it in a drawer. You must go through the process of submitting it, recording it, that's the official language, recording it with the county clerk. So that way there's a record of the transfer going into effect. So that's the transfer on death deed. For your vehicles, and this is going to include your mobile homes and your RVs. So this is, so sometimes we don't think of those as being motor vehicles, but they are considered motor vehicles. And so you would use a beneficiary designation of a motor vehicle. Now that is a form that you would complete along with the new title of registration. You would complete that and you would file it with the tax assessor collector's office in the county in which you reside. So the place where we do all of our car stuff, when we have to get new car plates, when we're registering a car title, right? When we're renewing all of that. So where you do your car stuff, that's where you're going to go and file it. And you're going to file it, and there is, and then what they will send you back is a new title that says it's a beneficiary designation title, and then you would put that in with your important papers, and that goes into effect immediately upon death. And so be sure that you do that. And so when you take care of that, then for a lot of people, you've done with those 3 things all of your major property that needs to be handled. You've gotten your payable on death account or with a beneficiary for your checking and savings account and your retirement accounts. You've gotten a transfer on death deed for your house or the land on which your mobile home is located. So you're going to have your transfer on death deed. That's how you're going to avoid the probate process for your house and land. And then you're going to have a beneficiary designation for your car, your mobile home, or your RV. And that's how you're going to avoid the probate process for that. Now, I will say this, for your vehicles, there is a very simple process afterwards. It's called an affidavit of heirship that can be completed. So if the only property that a person has, or one of the only things that has to be worried about is a vehicle, and there isn't a designation beneficiary designation already filed, have no fear. It's actually a pretty straightforward process on the other end. It may or may not necessarily have to go through the probate process, but it's, but why risk it? Now, I do recommend kind of think about it because it's not inexpensive to file the beneficiary designation of a motor vehicle. So, if you don't think this is going to be your last car, and finances are concerned, you can probably choose not to file that. But I would recommend it highly for RVs and mobile homes because those are types of mobile home vehicles that we tend to keep for 20, 30 years. Okay. One of the things to always be mindful of is that a transfer on death deed takes priority over a will. What does that mean? Is that if you have a transfer on death deed that gives your house to Susie, but then you have a will that gives your house to Bob, Susie gets the house. It does not matter when that will was written in relationship to the transfer on death deed. You write a transfer on death deed to Susie, you write a will afterwards to Bob, Susie gets the house. You write a will to Bob, giving the house to Bob. You do a transfer on death deed to Susie. Susie gets the house. It does not matter. A transfer on death deed takes priority over the will. Same thing with the motor vehicle beneficiary designation. And that's really important because if you think you're going to change your mind and do something, you need to revoke the transfer on death deed. You need to file a revocation or you need to file a new transfer on death deed to give the house to Bob if that's what you really want to do. So just be aware of that. Be aware that this is not ideal in all situations. I always, the best situations in my mind is really one person is getting the property. After that, you got to think about that individual situation. Having more than one person inherit property can create conflict, can create a lot of situations. Usually recommend if that's what you want to do, again, try to talk to somebody for advice to be sure that the transfer on death deed does what you want it to do in terms of giving the property to more than one person. The other thing it can't do is that it's not something you can put instructions on. You can put instructions into a will, but you cannot put instructions into a transfer on death deed. So if you want someone to be able to live in the house for the rest of their life because they're a person living with a disability, you want to be sure they always have a place to stay, but you really want all three children to be able to inherit the property, that you cannot do in a transfer on death deed. You must put that into a will because that's an instruction. Other types of instructions are, we're going to sell the house anyways, but I want the first $20,000 of it to go to Susie because Susie helped me replace my roof. And so it's only fair that Susie, who paid for my new roof, gets her $20,000 back when we sell the house after I'm gone. And so, but you can't do that in a transfer on death deed. It must be put into a will if you want it to be enforceable, because remember, verbal agreements, not enforceable. So just kind of keep that in mind. If you have instructions or more than one person is going to be inheriting the property, you may want to take a look more closely into whether or not we really want the transfer and death deed or put it into a will. Okay. A trust. Trust is part of advanced planning. It's an arrangement where one person or an entity called a trustee holds legal title to property for another person called a beneficiary. Many types of trusts: living, revocable, irrevocable, special needs. There's types of instructions in them. Lots of different types of things. I always recommend that if you think you need a trust, that you should speak to an attorney about whether or not you need it. Now, I will say this because I don't want to go too far into trust because it's very complicated and it's very much individual what needs to happen in that individual situation. But if the reason why you were thinking you need a trust is to avoid the probate process, that might not be a good enough reason. If you are watching national experts talk about estate planning and then they're talking about trusts and things along that lines, right? Typically, they are talking about it in a big picture kind of way. We live in the state of Texas. Texas law applies here. And believe it or not, I'm going to tell you as a lawyer, the probate process in Texas is actually not that bad if you have a properly well executed, a well drafted, properly executed will. And so and you're going to have that. You're going to hire an attorney, contact Lone Star Legal Aid or one of our peer partners to get legal services, or I'm going to tell you how to draft your own document. You're going to have your will in place. And when a will in place, the probate process is pretty straightforward, pretty easy. And so what makes it more complicated is not having a will. In other states, the probate process is much more complicated, much more expensive. They can last for years depending on the estate. I use the Elvis Presley estate as an example. That estate is still open. And it's like, so in other states, the probate process can be very complicated, very expensive. And in those states, trust is the estate planning, is the way that you prepare and plan. Because in that state, that probate process is going to be very complicated, very difficult. It's not to say that you may not need a trust. You may. I don't know. But it's individual, right? Right? It's an individual plan. But if the sole reason that you think you need a trust is to avoid the probate process, I just told you how to be able to do that for most of our assets. You're going to do a payable on death account for your financial accounts and your savings and your retirement accounts. You're going to have a transfer on death deed for your real property, your land and your house. You're going to have a motor vehicle designation for your cars, RVs, and mobile homes, right? And for most people, that's it. What remains now is the personal property. And you're going to have a will that's going to give instructions on what happens with that. Have a garage sale, sell everything, donate everything to my favorite charity. Take what you need, make sure grandma's diamond ring goes to who, oldest daughter per tradition. And then they're going to be able to take care of what they need to take care of because they have the will that gives them that instruction. There's no need for a trust to come in and get your clothing, right? So it's, so just kind of take into account, but trusts are needed in certain situations. So don't think I'm saying no, but we have to think about who's inheriting the property. High wealth individuals, trust is really important. We have to think about, minor children's and needing a trust for minor children's. So I'm not, sometimes you have to have a trust as part of your long-term care planning, which I'm going to talk about at the very end. So trusts can be something that's needed, but not only for the sole purpose of avoiding probate. Bad news. Most of the time I do talk about just what the documents are, but it's really important for you to be aware as you are kind of going through this that debt survives. The estate, not the heirs, is responsible for paying any debt owed, but it can be a little cloudy when we have community property subject to debt, right? And so it can get a little bit more complicated, but generally the heirs are not required to pay any debt, but the debt survives. So what does that mean? So things that are unsecured, credit card debt and things like that, medical debt. It depends on whether or not there's any assets in the estate to pay off that debt. It's a misconception that debt just goes away. It doesn't. It really depends on whether or not there's assets available to pay off the debt. And then there's usually a priority claim process to decide how much each creditor gets if there are assets available to pay off the debt. Some credit card companies may have chosen to write off the debt, but it doesn't mean there's not implications there as it relates to cancellation of debt income. So that's just a lot of words I just told you related to it. The most important thing is that when a person passes away and there is debt, that thing I told you at the very beginning, key takeaway, someone needs to go do something, go talk to an attorney. An attorney will be able to really explain what can happen with that unsecured debt based on the assets available and what will be kind of the expectations as it relates to paying off the debt, what happens if there is cancellation of debt, that type of thing for unsecured debt. What really matters, though, is secured debt. And I should have a car loan on this is listed there as well. So mortgages and car loans are secured debt. That means that debt is secured by property, which means if someone doesn't pay that debt, that financial institution that provided the money is going to come and take their thing back. They're going to come and take their house back. They're going to foreclose. They're going to foreclose the house. They're going to repossess the car. So if that's not paid, they're going to take it back. We don't want that, right? And so with a mortgage and a car loan, typically the financial institution will work with the executor or the heir to allow them time to figure out how to come up with the funding to be able to pay for that and get new funding to continue making payments on it, etc., right? So, but that's something you have to be aware of. If someone's going to be inheriting property subject to that debt, they have to be able to pay for it. Now, maybe you have a life insurance policy that can cover that mortgage, and then maybe you need to make sure that everything kind of lines up, that the beneficiary of the life insurance policy goes to the person getting the house with the understanding that the expectation is going to pay off the mortgage. Or maybe you want the executor to be responsible for that, and in which case you're going to name the estate has the beneficiary of the life insurance policy with the instruction to the executor, pay off the debts, and then let them inherit the house subject to that. There's things you got to think about. There's some factors to consider that. So that, again, individual plan, which is why I recommend you talk to an attorney to be sure that the planning goes according to what you need and want. So, but just be aware that the person inheriting that house and car, if there's a loan on it or a mortgage on it, they need to be able to continue to pay it, or you need to have something in your advanced planning, in your documents to help pay it on their behalf. So that way they inherit it free and clear of the debt. The other thing that's really important to remember is that if you have a reverse mortgage, that is different from a traditional mortgage. A reverse mortgage is that you've taken out a loan against the equity of your home, right? That's what a reverse mortgage is. Those are not, you can start paying that back while when a person is alive, but it becomes due 6 months from the date of death. And so is when a reverse mortgage is due, and that is pretty hardcore. Typically, a lot of those financial institutions do begin the foreclosure process pretty quickly. They don't tend to do a lot of negotiation. They may give you a week or two, but not always. And so it's really important to know that if you have a reverse mortgage on your property, that the person inheriting that is going to have 6 months to figure out how to pay that mortgage off or get the home sold so that they can pay off the mortgage. And so the types of things you may want to consider for that is maybe instead of putting it into a will, putting that into a transfer on death deed for a person and explaining it's like, hey, you're not inheriting this property, but you need to be able to sell this as quickly as you can so that we get the maximum value of your property. And not having a quick sale or foreclosure sale or things on that lines, and then the net proceeds be inherited and divided according to the will or whatever, right? It's per instruction. So that's an option. That's not the only way to deal with it, but they need to kind of be but that's an option to kind of consider. So if there's a reverse mortgage, be aware of that. You need to let whoever's helping you plan your documents know about that so they can give you some better guidance on how to prepare for that. Next up, in terms of planning for death, we have our disposition of remains. This is really just funeral arrangements. Who's going to be responsible for managing our funeral? It names an agent. It's kind of trying to avoid conflict in family and making it clear who's going to be bearing that responsibility for the funeral home, and be able to do that. You can include instructions in there, such as any prepaid arrangements or burial plots or any other instructions that you may have for the person who's going to be responsible for handling that. That's it for death. I told you that was going to be the big one. So we're going to cover the rest of it in this remaining 40 minutes, 45 minutes or so. But they go pretty quickly, I promise. So now we're going to look for caring for ourselves when we are no longer able to do so. So most of the time, this is going to be incapacity. We are no longer able to make decisions for ourselves or care for ourselves. There's one little asterisk. Should have put an asterisk on that, which is that sometimes we can plan for documents when we are unavailable as it relates to our own things. So, but for the most part, what we're planning for here is incapacity. We're still here, we're alive, but not able to make those decisions for ourselves. So the first one is kind of a transition kind of document. This is oops, I went too far. I clicked the button twice, which is supported decision-making agreement. A supported decision-making agreement is an agreement made by an adult that requests a supporter to help with decision making. This is not a power of attorney. We're going to talk about that next. This is I am acknowledging that I may need some help to make some decisions and be able to do some research, make sure I'm not harming myself in the decisions that I'm making. And so I'm going to name this person to kind of help me in this role. This supporter owes a fiduciary duty, which means that the legal obligation to do what is in the best interest of that adult who's requesting their help. But it is what that is. It's helping make a decision. It's less restrictive than a guardianship because the person has some capacity. They're not fully incapacitated. It doesn't require guardianship. They're able to make some decisions. They just need some help. But that would be it. So this is kind of serves in two different purposes. It's the aging up child. So a child who's turning into an adult, who may be living with a disability, and it's a known living disability, is somewhere in the spectrum of capacity, not fully incapacitated, not what we would kind of think of as being, a person with full capacity, but kind of in that between. Just needs some support. So that is one use for it, for someone to consider. The other use for it is as we are aging. As we are aging, sometimes our cognitive abilities do decline, and so it becomes a little bit harder to identify things that may be a scam, that may be, unclear. There's a reason why a lot of these scams are Social Security in nature, because they target an elderly population, because the ability to identify those scams becomes harder as we age. It's hard sometimes. Like True story. There's one just like about a week or so ago I was reading. It was clearly a scam, but it took a minute. Like I was like, and I actually ended up like asking my husband, like, look at, I'm like, I'm right, right? This is a scam, right? Like all the points were there. But between the two of us, we sat there and thought about it for a good solid amount of time. And we're like, that's good. It was good. It was a good email scam. And and so those get harder. They're getting clever. They know how to do it. And so supported decision making document makes it a little bit easier. Like, if a person is elderly, they can give it to the bank when if they walk in being like, I really want to send $5,000 to this person in another country that I've never met, but I've met them online and they're telling me this is happening, that the bank can call the adult and the adult can come in and be like, are you sure this is really what you want to be doing? Like, this doesn't look right. This isn't, and to try to stop the transfer from happening. That was obviously a result of a scam. So that's kind of an example of that. So very useful for people who feel like they may need that additional support. A statutory durable power of attorney is the power of attorney. This is where we have legal authority to make legal decisions and financial decisions on behalf of a person. And so this is where that asterisk kind of comes into play. Most of the time, these planning for capacity documents or planning for incapacity documents, we are anticipating we're no longer able to make decisions for ourselves. The statutory durable power of attorney can be effective immediately. And that is one of the things that makes it distinctive. So it can be you can choose to make it effective either way. You can make it effective immediately, where once you sign it and you execute it, the agent will have the ability to go across the street and open up a bank account on your behalf. If that's what you need, that's what needs to be done. So that will be immediate. No doctor required to say your person's incapacity. Or it can be springing, which means we are waiting for an incapacity before they are in effect. In which case, we would need a doctor's examination. A doctor will make a determination that the person is no longer able to make decisions for themselves, and then the power of attorney will go into effect at that point in time. There's no right or wrong, by the way, on whether or not you should make it effective immediately or make it effective springing, because it really kind of, again, your individual needs and your individual plan. Some people go ahead and make it effective immediately because they already have a person helping them. And so I can use my personal situation. I have a power of attorney for my mother. It's effective immediately because I handle my mother's bills. I pay my mom's bills for her and manage all of those things for her. And so to make it a little bit easier, so that way she doesn't always have to get on the phone with the bank every single time that I need to call the bank and do something over the phone with them, I have a power of attorney that allows me to do that on her behalf. And so it may be that you already have somebody kind of helping you doing things like that for you, that you might want to make it effective immediately, so that way you can just remove a barrier from them being able to do what they need to do. But it's not required. You don't have to do it. If you like me, for a long time, my mom would get on the phone with the bank. Eventually, she's like, "This is just silly," like, right? And so we changed her power attorney from being springing to being immediate. So it doesn't really matter. Like, it just depends on what you need and what you want. I do always recommend, this is again, bad news, Jesse, buyer beware. Be sure that it really is someone that you trust. If it's effective immediately, they can act on your behalf. They can open up bank accounts, take out loans in your name, do contracts in your name. They can do a lot of things in your name. It's a very, very powerful document. And so it's effective immediately. It can also, unfortunately, be a tool of abuse, and people can use it to steal and do things like that. So, obviously, I already told you, be sure who you trust and do things along that lines, but be very mindful. And just because you put this document into place and you trust this person doesn't mean you abdicate your responsibility and your ability to monitor your own stuff to be sure that that person is not abusing their powers when they should not be abusing their powers. And so to just kind of be aware of that. But that, again, financial, legal decision making for your statutory durable power of attorney. So, I'm going to tell you what I think when it comes to preparing for advanced planning as an adult, what the key documents are going to be. Everyone needs a will. I already told you that. You're going to want to be sure your checking account is going to be in some form of a payable on death account with a beneficiary. So take care of your property, right? So that's what you're going to do for planning for death, the minimum documents for death. For incapacity planning, you're going to want a statutory durable power of attorney. That's going to be your minimum document that you need there. Then on the other side is our medical power of attorney. So two different documents. We have going forward, we're going to have always two different documents, one for the care of our property and our legal issues, And then there's a care of ourselves, the caring of the person. And so that's the medical power of attorney. This names the person to make medical decisions when a person is unable to do so. And this is, again, we could be dealing with dementia, a coma, or it could be that someone is in a car accident and we're in a hospital and a surgery has to happen and a doctor needs a decision on what next steps to make in a surgery. That would also be when a medical power of attorney would be in effect. It is only effective at the time of an incapacity or an inability to make a decision, because as long as you are conscious and aware, you will always be the primary person making your own medical decisions. But this is your second document that's minimum protection. So when you're looking for planning for incapacity, you're going to want a statutory durable power of attorney and you're going to want a medical power of attorney. Those are your minimums. After this, it's highly recommended to have these documents, but if you're drafting your own documents because you can't afford an attorney and you don't qualify for services, and you're like, oh, this is so much, Jesse. You're telling me about 12 different documents. I don't really know what to do and how much I have to do. You can draft a lot of these on your own. That's not saying you can't, but if you're like, what are the absolute minimums? You need a will. You be sure you have a payable on death account for your checking account. You need a statutory durable power of attorney, and you need a medical power of attorney. That's your minimum. Everything else is good to have and highly recommended, but those four is what, at the end of the day, I want everyone to have. Right? So now going forward, we're looking at permanent incapacity. So one of the things about the statutory durable power of attorney and the medical power of attorney, as I mentioned, it can be temporary. It could be that you're unconscious because of a surgery. When you wake up, you're going to be able to make your own medical decisions kind of going forward, right? But when you're talking about dementia or a coma, we are eventually looking at a permanent incapacity. We're not expecting the person to regain the ability to make decisions for themselves. And that's when we're going to look at a guardianship. At some point in time, a medical provider or a financial provider, someone's going to say, stop, I need you to be a guardian. I need the legal authority now for you to be able to do that. So we had a power of attorney that was working to some degree, has a middle ground in between measure, but now we're going to have to go into the court and establish a guardianship in order to be able to maintain the person, property, and the health. And so a designation of a guardian names that preferred person in the event of a permanent incapacity. And the just as important for some people, that document can say who they don't want to serve, disqualifies the person. It's like, you know what? I never want Susie to be my guardian. I haven't talked to Susie in 30 years and I don't care. She's my sister. She's never going to be my guardian, right? And it's like, I'm going to name Bob, my brother. And then my alternate is going to be Jim, my best friend. Right? And it's like, and I know Jim's my best friend and Susie's my sister. Susie can never be my guardian, right? And so you can disqualify someone from serving in the role. This is what's really important to know, though. A guardianship is a court proceeding. So the court is going to be appointing a person. This document is not binding on the court. So the court is going to take it into consideration. They're going to say, okay, um, she's named Bob to serve as her primary guardian. I'm gonna take that into consideration. I'm gonna look at Bob. I'm gonna make if Bob can serve and there's no reason for Bob not to serve, then I'm gonna appoint Bob. But if Bob can't serve because he's not qualified, um, and I decide as a judge that he's not qualified to serve, then I don't have to name Bob to serve as that. Now I'm gonna go to Jim. I'm gonna look at Jim. All right. Okay. Jim, also not qualified to serve. I looked at it. If he had qualified to serve, I would have named him because my document says so. My document says that she wants a Jim to serve as her guardian in the event that Bob's not able to do so. But now Bob's not able to serve as a guardian. He's disqualified. So we're going to disqualify him. Well, now I'm going to start looking at next of kin. That's what the court's going to look at. They're going to start looking at next of kin. And then they're going to say, okay, well, next of kin is Susie. Oh, whoop, whoop, whoop. She says that she never wants Susie to ever serve as the guardian. She's disqualified Susie. That is actually binding on the court. So once you say you do not want a person to serve, the court will not appoint that person to serve. And so for a lot of people, that is just as important on who they can name. And so a lot of this is legally binding. So when I say that the court doesn't have to do it, they will follow it if they can. But you have to qualify to serve as a guardian. And if you can't qualify, the document is not going to force the court to override legal requirements, the legal qualification requirements. And so just kind of keep that in mind. Just like the power of attorneys, there's two types of guardianships. There's a guardian of the person deciding medical care, living situation, things like that, and a guardian of the estate, property, finances, legal matters. So think of it, guardian of the person equals the medical power of attorney. They don't have to be the same person, but like the role, like a similar role. Guardian of the estate, similar to the person who's got your statutory or power of attorney. Okay. HIPAA release. A HIPAA release is, so HIPAA stands for the Health Insurance Portability and Accountability Act. That's what it stands for. Most people don't know that's what HIPAA stands for, but it protects your medical records. It's basically electronic medical records, but it protects your medical record and cannot be shared by certain people who are covered by HIPAA without express permission. So a lot of misconceptions around HIPAA. And so hospitals, doctors, law firms, people who obtain medical information as part of their profession and that is part of the work that they do, we can't just share that willy-nilly with anybody. But if you tell your neighbor about your, medical situation and then that neighbor decides to go tell their neighbor about the medical, they're not governed by HIPAA. So they can share whatever you have shared with them. It may not be nice and maybe a bit of a gossip, and you may want to consider whether or not that neighbor's a friend. But that's what HIPAA protects. So HIPAA protects those of us who are in professions that obtain this medical information as part of our service to the client or patient. And so we cannot share that information without the express written permission by the patient or the client. And so that's what the HIPAA release does, is that we do recommend you do a HIPAA release for your medical power of attorney, and the person you name has your guardian of the person. So that way they are able to obtain medical information for all of the providers and you don't have to do one for every single individual provider that you've ever worked with. This is a generic blanket document that allows those two individuals, once they're in that role, to be able to get the information that they need. HIPAA can include more people than that. It can include your entire family if you want, where they can hear medical information from the provider, but the minimum is the two individuals you name for medical power of attorney and your designation of a guardian of the person. Next up is the advance directive to physicians. This is commonly known as a living will. This one is a tough one for some people because this is end of life decision making. We are talking about whether or not we want to have life-saving care or allowing ourselves to pass in certain situations. The two situations are a terminal condition. So a terminal condition is defined in the statute as a person has a condition that they are expected to pass even with life-sustaining treatment within 6 months. Think of stage 4 pancreatic cancer that's aggressive, right? That is typically considered a terminal condition. And so even with life-sustaining treatment, the person will pass. So that is a terminal condition. An irreversible condition is one that isn't life-threatening, but if there isn't an intervention, it can be. So think of a coma. A person can live in a coma for many, many years. But in order to survive, we have to eat. We need nutrition. And so a person in a coma would need to have a life-sustaining intervention for nutrition in order to be able to survive in a coma. So those are the two types of conditions. You can have a different choice for different situations. It's your decision making. For that, you can stop treatment and ask to be allowed to pass peacefully. And just keep me comfortable. Don't let me be in pain. Let me pass peacefully. You can also say you can use all available life-sustaining treatment. Do everything you can. I want to stay here as long as I can. I want to do that. And that's, again, you can have a different choice for terminal versus irreversible. There's no right or wrong here, and it's really up to you on what you want to do. But in your life-sustaining treatments, you can also put additional instructions into that. So some people have some strong opinions about certain types of treatment. So I will like any life-sustaining treatment, but I never want to be put on a respirator. If I need a respirator to breathe, I don't want that. In that situation, I want to be allowed to be passed peacefully. So you can also put those kind of nuanced instructions in there as well. There is a third option, which is a decision to be made by a medical power of attorney after conferring with a physician. So, so you can do that as well, where you can provide guidance to your medical power of attorney of what you would like to happen in certain situations, but ultimately that decision would lie with that person who's you named to make that decision on your behalf when you are unable to do so. We are talking again, unable to do so to make a decision at that point in time. These are complicated and hard decisions to make. If you are a person of faith, you may want to consider having counseling in these conversations, and talking to those guidance. Talk to your doctors about what these decisions may mean, especially if you have a diagnosis and putting these to effect if you have a diagnosis in effect. So have a conversation with your doctor about that. If you choose to have your medical power of attorney make that decision, talk to them, explain what kind of decisions you would want to be made on your behalf. Again, for some people, it's very personal in how you would approach this, but you may need to have some mediation, counseling in there, offer forgiveness for a decision that be made. Presumably, the person is someone who loves you and you're asking them to make a very hard decision. And that might be something to consider in whether or not you choose that option as a path. I will let you know that most of the templates that are available for an advance directive do not list the medical power of attorney option. You would have to find one that does. You would have to draft one that does, because most people usually pick an option. They have decided that they want one or the other in either one of these situations. So just be aware that a lot of the templates that are available out there don't have that medical power of attorney option, but it is something you can do if you choose to do so. It's also really important to know this does not replace a hospice plan. Remember, as long as you are able to make your own decisions, you will always make your own decisions. So if you go into hospice and you have made a plan, that will guide over an advance directive, even if they're in contradiction of each other. Okay. The last planning for incapacity decision-making document is a declaration for mental health treatment. This one is also known as a psychiatric advance directive, a PAD for short. This is actually really important for those people who are at risk of a mental health or psychiatric hospitalization. So think of a diagnosis of schizophrenia. So this is a person who's not incapacitated when they're on their medication, they're able to make their own decisions. They're fully in control of themselves. But if for any reason they should happen to go off their medication or there's a break in some form, and now they are incapacitated, right? Now they have become incapacitated. They have been hospitalized due to their psychiatric condition. So this directive is put into effect that gives the instructions on what to do as it relates to psychoactive medication, convulsive therapy, and emergency mental health treatments such as restraints and seclusion. Because when the person had capacity, they know the impact of these decisions on them, but they're not able to convey that information when they're not able to do so. And so really, really important, if you know anybody who is at risk of psychiatric hospitalization, they may not be aware that this document exists, and it's really, really important. Unlike the other advanced planning documents where you would kind of want to take a look at them when you have your major life changes, or maybe every couple of years if you haven't had a major life change, a declaration for a mental health treatment expires. They must be renewed every 3 years. So that is the only exception to any of these documents where there's a timeliness to redoing them and making sure that they're still in effect. All right. So now we're going to move into caring for those in our care. So we're talking about minors, and we're talking about adults for whom we have a guardianship over or whom we don't have a guardianship over, but we are caring for them and we need to be able to do that. And so that's what we're thinking about. But for most people, we're talking about the legal relationship, the minor child, legal relationship there, adult for whom adult ward for whom we are the guardian over, legal relationship there. The informal one gets a little bit more complicated because there's no legal relationship there, so it's a little difficult to plan for that because you have to have a legal relationship in order to be able to put together a legal document. So if you have a person who is under informal care and you've been able to kind of get by without it, but there's a need for a guardianship, you may want to consider seeking counsel to see if you should go ahead and put a guardianship into place. Or does that adult who is needing some care, do they need to put some documents into place while you are able to help them do that? So that way they can figure out the next steps when you're not available to help them. Okay. So in this particular case, we are looking at incapacity. We are no longer able to help people because we no longer have the ability and mental health to be able to care for them. We are also looking at unavailability. Unavailability, I know that's kind of a weird way to say it, but we're talking about death. We have passed away. We are no longer around to be able to do that, or we're just not around. We have moved for whatever reason. We're on, we're so I, again, using myself, when I was a child, my dad worked overseas. My dad was my mom and us, and we stayed here in the States while my dad was working overseas and on contract, and he was gone for a few months, right? So he was just unavailable, and so right, like that happens. Like sometimes people are just unavailable, parents are not available, and how do we make sure that in those situations that these individuals who are under our care are able to are in place to be able to get the decisions made? And so planning for death, you're going to put that in your last will and testament. So you actually can put that in there. So you should just be aware, usually the surviving parent becomes the primary custodian, right? So whether or not the parents are married, usually the surviving parent becomes the custodian or the conservator, custodial parent. There's different words for it, right? But you can, but in the event that you are a single parent or there's reasons that the surviving parent should not, you can name that in the will as well. So you would put that into the will for your minor children, which is why I talked about at the very beginning. Remember, you want to take a look at these documents when things change with your children because you're going to want to adjust your documents based on that. So it's not just your property. Your will is also going to have these instructions on who's going to care for your minors that are in your care, including property that they're inheriting, right? So that's what you're going to do there. You're also going to have, if you have a guardianship in effect, a designation of a guardian in the event of later incapacity or death. I should actually add that, or death, which is you're going to name a successor guardian. You're going to designate a successor guardian, just like when you're designating a guardian for yourself in the event of later incapacity. This is also the same. You're saying, this is who I am suggesting and recommending to step into my shoes when I am no longer able to serve as the guardian of my ward. And again, this court is going to take it as a suggestion. It will be taken into consideration, but not required if that individual cannot be appointed due to being disqualified. Next up is, so usually, again, we're talking about, most of the time, we're talking about who's going to be able to care when it's not the other parent, when the other parent is not available or should not be the person who's going to be there, right? Or cannot be for whatever reasons, right? So there is also a document called an authorization agreement for a voluntary adult caregiver. This can be any adult. It does not have, so it's a non-parent. So this is parents giving a non-parent the authority to care and make decisions for a child without a court's permission. Remember, parents always can do it, right? Subject to court orders. But like, if there is a court order. But like but generally parents can make all the decisions that they need to for their own children. So we are looking at a non-parent. This includes grandparents. Grandparents can't just do whatever they want with their grandkids, right? So they don't have the legal authority to do that. So this includes grandparents, aunts, uncles, like other people, right? Your village, however you define your village, that may be helping take care of children in the event that you are unavailable to do so. There's the permissions that this document gives are listed there. It's consent to medical treatment, get insurance for the child, enroll in school or daycare, consent to extracurricular activities, obtain a driver's license, get a job, apply for and receive public benefits, obtain copies of federal and state personal identification documents. All of this for the child, right? If the child wants to get a job, you have to get permission, right? Like type of thing, right? And so those are the types of documents that you need to put into effect. A lot of people put this into effect because they have a village helping them raise their child. And so this is a way for them to make sure that you have documents in place in the event a parent is no longer is unavailable to make those decisions for whatever reason they are unavailable to do so. In addition to preparing this document, you're also going to want to prepare a family binder for that person, right? Because you've given this person to consent to medical treatment, right? So you've given grandparent permission to have access to make medical decisions. Well, then, right. On the other hand, grandparent needs to know the medical history, right? They're going to need to know things. So you also want to be sure that with this document that you also maintain a family binder that has information about medication, household financial information, things along that lines, the information that that person, the non-parent will need to know in order to be informed and to be able to make the decisions that they are authorized to do so, right? So those are not documents that, like, I mean, there are checklists and things like that you can find online to be able to do that, but that's not an official document. That's just you kind of putting together a family binder that a lot of families already have, but being sure that that person, the non-parent, has access to it. Um, this is something that anyone can do unless there's a court order. Typically, you don't need good court's permission to be able to effect an authorization agreement. However, if the children are subject to a court order, you may need permission depending on what the court order says. So just be aware you can do this document, but if there is an existing court order or there's a pending court hearing around uh, children, then you should consult a family attorney about this before putting this document into place and whether or not permission needs to be given. Um, you will notice that that list of permissions does not include travel. And so you also, if you want, like my dad who worked overseas when I was a child, if he wanted us to come and visit him, where he was, he would need a travel authorization letter if my mom was not the one who's going to be taking me to him. If it's going to be my aunt taking me to him, then we would need a child travel authorization letter. It's known as a parental consent to travel form. So it gives permission for a minor to travel with a non-parent adult. Typically, it's going to be needed by immigration authorities, airlines, border officials, and things like that. Like, hey, we'll make sure no one's being kidnapped, right? I mean, not to be silly about it, but that's kind of what we're looking. So those are also documents that you can put into effect. Okay. All right, last but not least, in terms of our categories, is long-term care planning. This one's a little bit different, right? Everything else, we're talking about documents that you're just like, okay, in the event of, right? We all know we're all going to pass at some point in time. So that's not an if, but when, and then it's like, if we become incapacitated, if we become unavailable, here's going to be my drafting of the documents that we need to kind of put into play. And then you're going to just kind of put all that together. You're going to stick it into your important documents place and make sure that everyone has access to it, that need to have access to it, and that's what's going to happen. Long-term care planning is a little bit different. It is advanced planning and it is complicated. Remember, I start with individual plan for a reason. Everything is unique to what you need and what's going on with you. And so long-term care planning is really what we're thinking about is being eligible for benefits such as Medicaid while protecting our assets from creditors. And this does include the Medicaid Estate Recovery Program. And so we are talking about many people, I haven't looked at the percentages recently, but a lot of people at some point in time, and as we age, will end up in some type of a facility where we need some type of assisted living, right? We may either move into a facility or we are able to stay in our own homes, but we need in-home care or things like that, right? So a lot of us are going to be able to do that. That's actually quite expensive. And so some people will get long-term care insurance for that purpose and be able to do that. But for some people that don't have long-term care insurance, it can be quite expensive. They didn't apply for it soon enough, and so they don't qualify to get it. Now we have to kind of cover the expenses for ourselves. And Medicare only provides a small amount, relatively small amount of benefits for long-term care, and then at which point in time, once the benefits of Medicare are exhausted, then we start looking at Medicaid to be able to do that. Medicaid is based on eligibility, financial resources that are available to the individual before they can qualify for Medicaid. So that's what we're talking about when we're talking about long-term care planning to qualify for Medicaid. Now, the Medicaid Estate Recovery Program, for those of you to be aware of that and why we need to plan for this, is that if a person does use Medicaid benefits for their long-term care, their assisted living care, then the state has a right to recover the amount that they spend for it, right? So after a person passes, they can come to the estate and say, hey, we would now like to recover what we spent, what the state spent towards the care. And so, well, then all of your hard-earned estate is now going to go back to the state rather than going to your heirs. And so we don't really want the home that someone is living in to be recouped, right? We want to be sure that they're going to do that. What if there's a minor child or an adult living with a disability for which the inheritance is going to be key to their support and long-term care, right? So we want to be sure that we are taking into account that we need to preserve that estate for the heirs and beneficiaries after the person has passed away. And right, so there's kind of this two-pronged thing. What do we need to do to become eligible for Medicaid when we are unable to pay for long-term care? We don't have the assets to pay for long-term care. How do we become eligible without bankrupting ourselves? And then how do we protect the estate for our heirs and beneficiaries when they need to inherit it? Well, not only they need, because you want them to inherit it. You want your family to inherit things, right? And so how do we make sure that we protect it? So it's kind of this two thing, but it's kind of served in the same way. The way to protect your property to become eligible is also similar to the same way that you protect the property for your beneficiaries, but they can be a little bit different. So what are a couple of ways you could do that? For your real property, this is known as an enhanced life estate. This is commonly known as a ladybird estate, a ladybird deed. And so this is a way to transfer property into a trust, or not into a trust, it's into a deed, a way of owning the property that makes a person qualified. A transfer on death deed can also can also do the same thing. But again, nuance. There's some nuance on why one would be better than the other, depending on your individual situation. So that's going to be for real property. For income, when you have spouses and one of the spouses needs to go into assist, needs to be qualified for Medicaid benefits, but the other spouse is continuing to work, and that income that's coming in from the other spouse is enough to disqualify the household from being eligible for Medicaid services for the one who needs it, you can do what is known as a qualified income trust. It's a Miller trust where the income goes into a trust, and that allows that spouse who needs Medicaid to now become eligible for that. A Miller trust is irrevocable. Once it's put into effect, you cannot change it. And so, but it is a way to kind of think about it. This is complicated. This can be its own hour-long presentation on what it means to be eligible for Medicaid and benefits and what you need to do on that. So this is a very complicated area, very personalized, very individual. So you really should consult with an attorney if this is something that you're thinking about. And for some people, we know it's coming, right? We know it's coming because of family history of certain types of illnesses where we know assisted living is going to happen. There's also just the practical realities that as we age, we're going to need it because not everyone is able to maintain the same level of cognitive abilities, physical abilities, and things along that lines. And so there's also a practical expectation there. But I do recommend that if you are thinking about this and you need to plan for it, that you should talk to an attorney. So that way the best plan can be put into place that's right for you and your family, and what is true for your property and things along that line. So it is complicated. Okay. All right, that's it. Oh my goodness, look at that, 2:45. So help is available. I know there's a lot of stuff. Again, this is going to be recorded. You can go back and rewatch a section of this if you have any, want to go back and do that. So feel free to do that. But if you qualify for services, again, don't self-select. You may qualify. A lot of people do. It's actually an estimate is between 20 to 30% of the state will qualify for services. It does depend, so don't think that you don't qualify. But so that's me at the top, Lone Star Legal Aid. And again, that's right there. But our partners in AMOS includes Houston Volunteer Lawyers, the Earl Carl Institute. Those top three were legal aid providers. So based on financial eligibility, we can assist with your documents. The Houston Lawyer Referral Service is a service of the Houston Bar Association. They are private attorneys. So if you can't afford an attorney, this is how you can find an attorney who can do that work for you. You can contact them. They will give you the name of 2 attorneys that are in the private bar who do this work. Some attorneys do offer a sliding scale based on ability to pay, but that does depend on the attorney. There's no expectations there. I cannot tell you what they're going to be. Don't ask me how much they cost. I do not know how much the private attorneys charge for these types of services out there at this point in time. I will say this, though, this is a trusting relationship. when you're working with an attorney, this is very personal, right? You're dealing with some hard things sometimes, and depending on your situation. And so if you don't like the two attorneys that you meet, you don't feel like you got the right rapport with them, get another two attorneys. Go shop around. I want my clients to be comfortable with me. And if you're not comfortable with me, then you shouldn't be with me. You shouldn't hire me, right? Well, you wouldn't hire me, but like, you know what I mean? But it's like, but so be sure that, that you have a good relationship with the attorney. Don't pick the first one. If you are wanting to move forward with drafting things yourself or want just more information to read on your own, the Texas Law Help is a service of our Texas Legal Services Center, which is also one of our partners. It's a wonderful website with lots of information, many different topics, not just estate planning, but probate, housing, all that. All the documents that I talked about today, you can find those with more instructions, more details, some frequently asked questions around those at texaslawhelp.org. So you can do all that. By the way, you will get a copy of the templates that are available that we will send as well. And so that's going to be available. But Texas Law Help is a wonderful new resource, another resource that you can go to get more information beyond this primer that I just gave you on advanced planning today. We do have some upcoming programs to kind of take into account that if you want to do some further things. Again, today I was talking very much about all of the before. Some of you may have come today because you have questions about the after part. Someone has passed away and you are wondering what to do about how to clear title and things along that lines. My good friend Lisa is going to be presenting next Thursday, same time, same place, on Thursday, February 3rd, on clearing title to inherited property. So feel free to sign up for that one and check that one out. If you want to apply for services and you need some assistance, not just on estate planning, but other things, but we will be, in addition to Lone Star Legal Aid, but other partners are going to be a coffee and conversation resource fair at Acres Home on Wednesday, February 19th from 10 to noon. So feel free to drop by. It is going to be first come, first serve, and we may not be able to provide legal advice at that moment, but we can at least get your information and schedule a call if we cannot do it the day of. But this is where you can come and apply for services if today I have convinced you that you need this, and I hope I did, because you need your you need your four things, right? Come out to Acres Home on February 19th. And then again, I will be doing my second part, which is how to draft your own documents and draft your own will and transfer on death deed using the Supreme Court approved forms. And then I will talk a little bit more about the details of what's required in drafting a will on Thursday, March 6th. So in exactly 1 month from 1 to 3 o'clock, same time, that channel. All right. I always like to end with a little silly comic, which today is Miss Chicken is at her attorney's office, and it says, "I want to leave all of my estate to my sister, but if she's not living, then entrust for her eggs." If anyone has any questions, feel free to put it into the chat or unmute yourself. We do have about 10 minutes and happy to answer questions. I'll go back to the resources. That's usually what people want to know about.
Okay, great. The resources that are available here, as well as a copy of the templates and things, or the information that Jesse has gone over for you this afternoon. I will be sending out a link of this recording along with those documents and along with these resources for you guys to go back and to review as well. So don't think that you're supposed to remember everything that she just talked about here today. So again, remember I told you there's going to be a lot of information that's going to be covered here today. So we definitely want to make sure that you guys walk away with enough information for you to kind of be empowered to know what decision that you want to make, whether it's applying for service, whether it's trying to create and draft your own things, that at least you actually have the information and kind of know where or how to get started, or what to actually look at. But we definitely encourage you to come back next month for March the 6th presentation as she dives into a little bit more detail about drafting those documents. But there are, again, options that are available to you. Now, my internet was doing some weird and funky stuff, so I've gotten kicked out of Zoom a few times. I do not know if every time you move out and come back in, it erases the chat. So I have no idea if there were questions that were input before the last
there's no chat questions.
Oh, okay. Even better, even better. I did have some that were sent to me in advance that were emailed. However, you pretty much kind of went over all of that. Someone had questions about having a blended family, what do those documents actually look like. You kind of covered a little bit about trust, but knowing that that's an individualized situation, that you definitely should be able to should need to contact an attorney about that. Um, Learn about how to place my name on my parents' property. That we can get into a little bit more detail about the for inherited property and what those documents look like in affidavits and all that's going to be kind of covered in part two. You went over Lady Bird deed already. That was another question. Someone had a question about guardianship and how does she choose and select um, a guardian in the event something happens to her for her minor child. Let's see. Amend an executor. If you have an executor for an estate, how do you amend that?
You would amend the will. You would either execute a full-on new will or you would do a codicil. That a codicil is just an amendment to the will, just updating the name of the executor. A codicil has the exact same execution requirements as a will does. And so it's not just enough to just write it out and attach it to the will. Like you have to go through the same execution requirements has the original will when you did it the first time. But yeah, it's either a brand new will or just a amendment with that.
Okay. I'm checking the social media pages too, just to be on the safe side to make sure. But I don't see any other questions there. I think this is the first time in quite some time that we had no questions in the chat and nobody had questions afterwards. So
Hold
goes
on,
to
I
show you
just got a
how
question.
okay.
So there was a question about, it was directly to me, but I think it applies to everybody. So I'm going to go ahead and answer it, which is the look back period as it relates to the Medicaid transfer. So yes, so there is a look back period. So they can look back at transfers of property in the previous 5 years before death or before becoming eligible for services in terms of like, oh, are you trying to become eligible when you shouldn't be eligible type of thing. So it is 5 years, and as a general rule, it is 5 years. So we're looking for eligibility. That is something to be thinking about. So just kind of be aware. So if you think that you're going to need it, you would probably want to do the Lady Bird sooner rather than later. But it doesn't mean that the Lady Bird automatically is not effective just because it's less than 5 years. There's some different factors to look into that. But if we're not looking at eligibility, if we're just looking at trying to preserve the estate, then a transfer on death deed, the 5-year look back does not apply.
Okay. Are there any other questions? I know Jesse did kind of go over some other upcoming workshops that we've got and what's going on for the remainder of the month. But I also will be including a copy of the entire month's calendar in the email that I send out to you guys. But really quick, on Tuesday, the 11th, we also have a bankruptcy basics where we're going to have a representative from with Lone Star that's going to be also presenting that information about bankruptcy and bankruptcy laws and things as it relates to Texas. Part two of this particular series about clearing title for inherited property is going to be presented next Thursday. Oh, she's got it right there on the 13th from 1 p.m. We have a community resource fair hosted by the City of Houston's Department of Neighborhoods. It's going to be on the 19th. So if you want to actually come out and apply for services and complete intake and things like that with our attorney organizations. Some of them will be present at that time, and you all will be able to do that as well. Know that also on Saturday, the 22nd, and I just posted it on the website, that we've got a Todd clinic that we're hosting in conjunction with the Earl Carl Institute, as well as Jesse did really quick talk about reverse mortgages and kind of how they relate. And we have a reverse mortgage presentation that's going to be coming up on March the 4th, if you guys are interested in that. So there's a variety of different workshops and information that we provide throughout the entire month. And throughout the year, actually. So again, if there are other presentations or topics that you guys may be interested in, then definitely make sure that you reach out to us, any one of the partners, and kind of, give your input. There's a survey link that's going to go out on the screen, asking you just to kind of take a couple of minutes and just say, hey, let us know how we're doing, what you think, how was this information that was provided, was it beneficial to you guys, and if there are other subjects and things that you guys may be interested in. So we would love to have your feedback and your input about that. So the presentations that, again, that we do offer are at because of volunteers like Lone Star Legal Aid and Jesse, and taking time out of their schedule of the days to provide this information to you. They do this on a voluntary basis. So we wholeheartedly appreciate the partnership, the presenters that we do get, because they have an interest in making sure that information gets out to the community. So do keep that in mind as well, that these are professional volunteers. We try, as much as we try to keep up with the most up-to-date information, we don't always have it. So we want to rely on those professionals that do this for a living to bring this information to you guys. So know that information that is presented by professionals in those fields. It's not coming from us. So us meaning me. Okay. We do rely on those attorneys and things like that. But again, we want to thank you guys for joining us this afternoon and coming back. We know it's the first of the year. We're still trying to get reacclimated and back into doing the swing of things, and kind of getting these things kicked back off again. So we want to thank you guys for joining us this afternoon. Look for the follow-up email to come from me, along with the contact information and the link to apply for services for Lone Star, if you guys are interested or in need. So with that being said, thank y'all very much. We appreciate y'all for coming. You all have a wonderful remainder of your day. Take care of yourselves, stay safe, and we will see you all next time. So thank you, ma'am. Thank you, Jesse.
Bye, everyone.
All right.